Hello, listeners. Welcome to YouTube and Podcast Law Reader channel. Today we'll read the Chapter 3, Living Modified Organisms, Part 1, Import and Export of Living Modified Organism. For you start from Article 41 to 48, Article 41. Importation for direct use as food, animal feed, or for processing. 1. The first importation of living modified organisms into Cambodia for direct use as food, animal feeds, or for processing shall have a risk assessment conducted and receive prior approval from the ministry responsible for environment and natural resources before applying for importation authorization from the competent ministries/institutions. 2. Persons intending to apply for importation authorization of living modified organisms as in paragraph 1 above shall provide written certificates from competent ministries/institutions of the export country affirming the accuracy of information of living modified organisms to be imported to the ministry responsible for environment and natural resources for review. Article 42. Decision-making procedure for importation. 1. The ministry responsible for environment and natural resources shall provide a written response stating that prior approval is granted or declined within 65 days at a maximum to the applicant from the date of receipt of the application. 2. The ministry responsible for environment and natural resources may grant approval with or without condition for the applicants to provide additional information or decline the application after receiving risk assessment results and other required documents. 3. At a maximum of 180 working days after receiving the application, the ministry responsible for environment and natural resources shall provide written notification to the applicants and the Biosafety Information Network about its decisions. 15. 16. 4. When the ministry responsible for environment and natural resources approves living modified organisms for direct use as food, animal feeds, and processing, the ministry responsible for environment and natural resources shall notify all members of the Cartagena Protocol via the Biosafety Information Center within 10 days. 5. An approval letter by the ministry responsible for environment and natural resources shall attach living modified organisms importation authorization. 6. Procedures, requirements, and conditions for decisions shall be determined in a process of the minister responsible for the environment and natural resources after consultations with competent ministries/institutions or subnational administration. Article 43. Procedures before exportation of living modified organisms. 1. Persons intending to export living modified organisms from Cambodia shall notify the competent institutions of the country of importation in writing before applying for exportation permits from competent ministries/institutions in Cambodia. 2. Competent ministries/institutions may issue living modified organisms export permits from Cambodia after receiving written approval from competent institutions of the country of importation. Approval letter from the party of importation shall attach export permits and other packaging and export handling documents. Article 44. Exportation approval letter. Exporters of living modified organisms from Cambodia shall have a written approval letter from the ministry responsible for environment and natural resources affirming the accuracy of information related to the export of living modified organisms. This approval letter shall attach export permits and or other packaging and importation handling documents. Article 45. Document preparation. 1. In cases where there are separate legal provisions pertaining to persons intending to import or export living modified organisms from Cambodia for a specific purpose, attachments affirming the specifics of the identification of living modified organism as actual living modified organisms, and affirming the safety requirements in packaging, handling, transportation, utilization, and storage shall be provided. 2. These documents shall be attached to the goods during cross-border movement and during transportation to the place of export/import. 3. Exportation or importation of living modified organisms from Cambodia shall come with the following conditions. A. Living modified organisms for direct use as food, animal feed, and processing shall include information that these goods may contain living modified organisms and are not for intentional introduction into the environment. B. Living modified organisms for intentional introduction into the environment shall have specifications on their identity, characteristics, related features, safety, requirements in packaging, handling, transportation, utilization, and storage, and on the contact information of officials for further inquiry, and specifying that cross-border transportation of living modified organisms complies with provisions for exporters, as in Cartagena Protocol. C. Living modified organisms for contained uses shall be identified as such and contain specifications on safety requirements in packaging, handling, transportation, utilization, and storage, and on the contact officials for further inquiry, including names and addresses of the officials and institutions to hand over living modified organisms. Part 2. Liability for harm and response measures. Article 46. Obligation of persons that have caused impact or harm. 1. The project owners whose activities or operations are related to living modified organisms and cause environmental, social, economic, biodiversity, or property impact or harm due to their activities or operations shall fulfill the following obligations. A. Promptly notify the ministry responsible for environment and natural resources about environmental, social, and economic impacts or harm to the environment and natural resources. B. Conduct an initial impact assessment on environmental, social, and economic impacts or harm. C. Take initial appropriate response measures. Article 47. Self-measures by the ministry responsible for environment and natural resources. 1. As soon as a notification about the environmental, social, and economic impact or harm as provided in Article 46, obligation of persons that have caused impact or harm of this code, is received, the ministry responsible for environment and natural resources may take necessary measures to prevent or mitigate the impacts or harm if the ministry responsible for environment and natural resources found that initial response measures by persons stipulated in paragraph 1 of Article 46, obligation of persons that have caused impact or harm of this code are not appropriate. 2. All costs related to the above measures are under the sole responsibility of the persons whose activities or operations are related to living modified organisms and that have caused environmental, social, and economic impacts or harm. Article 48. Environmental, social, and economic impact assessment. The ministry responsible for environment and natural resources shall conduct an environmental, social, and economic impact assessment caused by the person stipulated in Paragraph 1 of Article 46, obligation of persons that have caused impact or harm of this code. Thank you for listening, and see you in Article 49. Have a beautiful New Year Day 2025.